This is the current federal tax developments for the week of January the 27th, 2025. Current federal tax developments are brought to you by Kaplan Financial Education and by your state society of CPAs. This week, we're going to look at a few issues. First, we're going to start out looking at a case involving funds taken by a sheriff and whether they were a valid loan or not, and so whether that was income from embezzlement to her or not. We'll talk a little about that unique situation, how it got resolved, and why the court decided that even though she took funds she shouldn't have taken to make a loan, though it was not considered to be an embezzlement because she did not have intent to keep it. She had an intent to get it repaid. We'll also talk about the tax court looking at a conservation easement. The court in this case allowed a deduction for the easement at a greatly reduced amount, but it didn't agree with the IRS that certain concepts made it automatically not a qualified deduction. So we'll talk about why some deduction was allowed here, even though the court pretty much agreed with the IRS that the actual valuation was way off by a huge factor. We'll talk about an IRS chief counsel advice that discusses issues with the activity of a private foundation with regard to self-dealing, attempted correction of their self-dealing, and making jeopardizing investments. This is how it's not really your money type of problem when you set up a private foundation, and how a taxpayer got into a bit of a hot water, at least in this exam. I assume it's going to be a not thrilling rest of the exam following this chief counsel advice coming down, instructing the agent on what the options should be. Certainly we know the IRS position at this point. We'll also talk about an IRS email that discussed the agency's lack of obligation to process any amended tax returns you file asking for a refund. We'll do a little bit of discussion there, but also talk about what options you have if the service does decide to do the equivalent of, borrowing a phrase from the 1970s, simply stonewall it, delay, hopefully make it go away, how you can make it not go away, but how that might not be the best solution from a practical standpoint. We'll talk about the Supreme Court. We're back with the Beneficial Ownership Information Report. And quick title, as of this instant, I'm recording this on Sunday. We're back to where we were a week ago. However, we have now had new developments that got us there in a weird set of movements. And more importantly, we are set up for it changing again rapidly to having to file the reports. But that's going to depend largely on what the Department of Justice does and the Treasury does going forward. So we'll talk a little bit about that, how we're in the position we're in right now, and also, what would make the next change in line. But we did get the Supreme Court's ruling on the CTA. And if you want the CTA knocked down, I would say the ruling is not a positive, shall we say, based on a couple of issues involved with the ruling issued. It's not technically a ruling on the validity of the CTA overall, but certainly it suggests the way the court's leaning. Okay. And so we'll talk about both that action and the fact that we still don't need to file, at least we didn't as probably Monday morning, whether that's still true on January 28th, or whether it will always be true or never be true again after a 28th, we don't know. We just have to keep going. So with that, let's go to our first case. This is a case of Franklin v. Commissioner, Tax Court Memorandum Decision 2025-8. This came down on January 22nd, 2025. Now, you may remember a while back we had a case involving Alabama's unique rule that for many years, the state, instead of providing food or basically money to feed inmates in county jails to the county, they provided those funds directly to the sheriff. And the sheriff, therefore, would expend from those funds to make the payments from what was now under their own control. And they would then, if they had excess funds, they got to keep them. And if they ended up with not having enough funds, they had to make up the difference. So it was a unique structure, to say the least. And, it changed now. No longer does Alabama work that way. There were a couple of rather well-known, including this one to some extent, cases of things going really, really off the rails with, shall we say, some sheriffs who maybe weren't the best custodians of public funds in that structure. I think we'll just phrase it that way. Or at least in this case, certainly made a rather dumb move regarding those funds. So we'll talk a little bit about the case. But it is interesting that we've had, as I recall, over the past few years, that this is the second case we've had involving this same structure that Alabama had for years, but apparently just recently became one that they decided, hey, wait, that's my money, so things start happening. Now, this was the taxpayer in this case was the sheriff of Morgan County, Alabama, from 2011 to 2019. As I mentioned, as sheriff, she was responsible for feeding the inmates in the county jail with funds provided by the state of Alabama, right? So this monthly allowance was allowed. She could retain any surplus, and the federal government provided a separate allowance for federal inmates that she was holding in the jail. Now, she established a checking account, which would be referred to as the jail food money account, to receive the state and federal funds for feeding the inmates. Now, again, this is an account under her control, not the county's. So again, that is probably unique. At least I don't think here in Arizona. We haven't ever done anything like that here. We've had some interesting things with feeding inmates at the county jail, including the green bologna. But the green bologna years ago was still going through the county's funds. So we had that little background. Okay. In 2015, she withdrew $160,000 from the jail food money account. Much of this was going to be to invest the funds, in our sense, to earn a return. Because again, she's responsible for paying for any excess of foods. And the county had already gotten in trouble with her predecessor about, you might guess that this provided an incentive for the predecessor to be extraordinarily cheap about the food provided to the inmates and not worry much about whether it met nutritional requirements. As you can guess, that kind of went south. And so there was an order out there. And that order had a couple of provisions in it, but one of which did restrict the use of the funds by the sheriff. Now, she and her counsel had decided that it only applied to the prior sheriff, that some of the general parts applied to the county as a whole, but the specific order that the sheriff couldn't take funds and do certain things with them, that she decided was really, it only applied to her predecessor, not her. As we'll discover, later on, a court in Alabama kind of came to the opposite conclusion, but we'll get there eventually. But she took that out. She loaned the money to Priceville Partners, a car dealership, with the expectation of a 17% interest rate on that loan, based on a recommendation by her boyfriend. Hint, probably not good to take recommendations from your boyfriend or your girlfriend for investments unless they have some special expertise in the area. And it turns out that no, this was a Ponzi scheme. Now, her boyfriend was not in on the Ponzi scheme. I get the feeling that he was kind of a victim as well. But, it was like Madoff. It was too good to be true. And yeah, it did. So the loan was not repaid by this partners. In December of 2016, her boyfriend did repay $150,000 on behalf of the partnership, right? And she deposited those funds into the Traditions bank account, the jail food account. So the funds were returned eventually. But obviously, this is kind of an embarrassing side route. Part of the reason why I suspect that eventually the state of Alabama decided that we're just going to change this. Yeah, this is getting a lot of hand as we're doing it. In January of 2017, the court found that she had violated, remember the consent decree? The part that she thought only applied to her predecessor? Well, the court decided that really it applied to her. So, in essence, when she removed $160,000 from the jail food account not to pay for food, that was a violation of the account. Now, she was held in civil contempt, but she was only fined $1,000 because she had returned the funds to the account. She was not, basically, she might not have made the smartest move in the world, but she wasn't really intending to take the funds and run with them. Right. That'd be the key. She put him back in. At the time, the court also terminated provision of the consent decree restricting the use of jail food funds. So they got rid of that and, had a back and forth on that. And as I said, Alabama was in the midst of changing the structure. Now, on her 2015 income tax return, that's one, remember, where she took down $60,000 out of the account. She filed her 16 return in December 2017, or 15 return. As you might guess, that's a bit late. Okay. But she reported the wages and other income from the county, but she did not report any income from the withdrawal of funds from the jail food account, right? She didn't pick that up as income. She later pleaded guilty to willful failure to file a tax return for 2015. Yeah, it's like, turns out, she was kind of aware she should have filed in April of 2016, but didn't quite get around to it. So eventually they caught up with her and she was done. Had to file the return. My guess is they caught up with her because of publicity about all the other stuff that was going on involving the jail food account. So that's kind of where the fun comes in, right? All of these things happening. She needed to get that return together. Now, her 2018 tax return, she reported wages and other income. She also included a Schedule C listing her business as Sheriff's Jail Food Account, reporting gross income of $44,967 with an offsetting deduction for legal and professional expenses of the same amount related to the legal and tax issues resulting from her actions regarding the jail food account. So she basically took a deduction to offset that. That was her background there. Okay, so now the court's trying to unwind this. Right? The IRS issued notices of deficiency. In a 2015 notice, they initially determined that $155,000 withdrawn from jail food account was unreported gross receipts from a trade or business. But they later amended this to allege the funds were income from embezzlement. And as you'll discover, the IRS doesn't want to concede there's a trade or business here. And we'll get to that kind of where we're at. For 2018, the IRS disallowed the deduction of $44,967, arguing the petitioner was not operating a trade or business. There's the hitch. If in 2015 that was a trade or business, then potentially those legal fees and other things could be deductible as offsets to trade or business income. And that could be a problem for them. So they kind of changed their position. So fundamentally, at the end of the day, the IRS was arguing that she had embezzled $155,000 from the food account. And because of that, that was omitted taxable income on her 2015 return. Let's see what the court thought about that. The court decided, as I've kind of already told you, the $155,000 was a loan, not embezzlement income, because, the withdrawal violated the consent decree, but she intended to repay the funds. And the court also noted she was never charged with embezzlement or theft when all of this came to light, right? They went after her on the civil side. They went after her for, misusing things and making a dumb move is probably the best way to phrase it. But they didn't go after her for criminal embezzlement, right? And because the court determined it was a loan, not embezzlement, she was not entitled to an NOL. Because again, they're determining that not only that, they agree with the IRS, it's not considered to be, income. And so the problem is if we pull this off, well, she might have had some offsetting deductions from the jail food account, which could have been an NOL that would have been carried back. So they're saying, nah, that's not what we got. The court sustained the addition to tax for failure to timely file as she did not establish reasonable cause, and she pled guilty, right? She pleaded guilty to the charge. So they're saying, you told us you basically willfully failed to file the return for 2015 on time. You're going to be penalized for that. The 25% failure to file penalty is going to come into play because you were, late enough for that to come into play. So I'm sorry, Sheriff, but, it's really, really tough. And honestly, it's tough to show reasonable cause for doing a criminal violation. I guess that's kind of the way you phrase it. So we have a little problem there under the Internal Revenue Code. They also disallowed the 2018 deduction for legal and professional expenses, right? The court noted that she was an employee at the time, and they can be considered being a trade or business under a couple of cases they cite, but the expenses would be considered miscellaneous itemized deductions. And as we know, in 2018, wrong year, Sheriff, they wouldn't have been deductible. Even if the legal expenses were related to her status as an employee and not as a separate trade or business, they still would be considered non-deductible miscellaneous itemized deductions. So bottom line, it doesn't really matter. She can't get it. It's not an above the line trade or business. So we don't have to really decide if there was a trade or business involved in this related to an employee. Just doesn't, it doesn't work. And they also disallowed her tax preparation fees, which probably makes sense. Again, 2018 miscellaneous itemized deductions were gone. So in any event, it's an interesting discussion, and it's interesting look at how she got off here. And again, remember, obviously she made a dumb move. That's pretty straightforward, and it wasn't really a move she should have made legally. But the court nevertheless found that she never intended. She just made a stupid move investing investing funds that she was holding kind of in trust for the county. That was a stupid move. But she had never been charged with embezzlement, and the court found that she had an intent to repay. It wasn't as if she just thought she could walk off with the funds. So that's how we get to this case. Okay, next up, we're going to talk about a conservation easement case. Seabrook Property LLC et al. Versus Commissioner. Tax Court Memorandum Decision 2025-6. This one came down January 21st. Okay. Now, in this case, we have a claim deduction on the partnership's return, right? A claim deduction of just over $32,500,000, just over that, based on the appraisal of that valued the land approximately $58,000 per acre before the easement. They're saying we gave this, we now have this big $32.5 million deduction based on our contribution of a qualified conservation easement on a piece of property, right? Now, the appraisal valued the property before the easement at $37 million and after the easement at $1.15 million. So we have that. So again, a before-after calculation involved. But before the easement donation, there was an option agreement to acquire Ms. Belford, who is a member of Seabrook and had the properties, 97% interest in Seabrook for $4.74 million. They acquired that interest in December of 2017. Now, that's going to come into play because the issue is going to become, obviously, you look at first glance and go, wait, who in the world would have sold a 97% interest in a partnership holding a piece of property worth $37 million or less than $4.75 million? I mean, that suggests something's not quite right here with what's going on. I mean, why, either Ms. Belford is completely incompetent at managing finances, which it does not seem she is, or it seems like maybe there's an inflated value going on here. And that maybe that's kind of the point here, which is what the IRS is getting at when we come to here, and it becomes part of it. Now, the IRS says, look, with that inflated value and with what they were selling the interest for, there was absolutely no donative intent on behalf of any of the partners acquiring their interests. They were not making a disinterested donation to a charity in exchange for, not receiving something back. They rather were putting, let's say, $5,000 in to buy, what will end up being, let's say, a $25,000 deduction, and therefore a reduction in their income tax of well over the $5,000. So they were in essence buying something, buying at $5,000 and getting effectively with a reduction of their tax bills more than enough to offset that entire $5,000 and cover some other stuff. They're saying there's no donative intent there. You can't make a charitable contribution without donative intent. They also claimed there was not a qualified appraiser. They said there was issues with the appraiser and the appraisal, and the donors should have known the appraisal would overstate the value of the property, implicitly stating, knowing that you're buying for, let's say, $5,000, and you've been promised a deduction of $25,000 coming up in the future, in the near future, you had to expect that appraisal was going to be overstated wildly. And because of that, if the partnership was aware of that, then that is one of the disqualifying items for a qualified appraisal, I'll get it right, under the code and regs. And you must have a qualified appraisal for basic claim of deduction for something like this. There also were issues with the report itself missing certain items and other issues. So the IRS says, well, even if Court, you don't buy the donative intent argument. There's no qualified appraisal. So therefore, they couldn't get a deduction. And the IRS finally says, well, if you do think there's a qualified appraisal and you do think there's donative intent, well, the easement's grossly overvalued. The tax court's only going to agree with the third part of this. They're not going to accept the first two. Important to understand what they do, right? The first two issues the IRS is going to lose out on, right? What they said was there was no quid pro quo contribution. It wasn't, the charity was not giving back an asset or assets or something to the partnership that was worth more than the, that was worth, basically, that was a return on what they're giving. So it's not like I gave you $5,000 and you give me 40. They said the tax benefit's a tax benefit, but that's simply mechanical application of Internal Revenue Code. And, we don't disallow, because again, you're not allowed to take a deduction for partial interest if the tax benefit of your contribution is, the federal tax benefit from the deduction is such a quid pro quo benefit, then you never could claim a deduction for anything, to be totally honest. That's a fundamental flaw in how the service viewed this. So the court said there's nothing wrong necessarily if in the real world you had a piece of property that you'd bought for $5,000 that does appreciate dramatically over the next year, and you donate it and you get a deduction for $25,000 for the easement donation on the property. That doesn't show there was no donative intent. Even if maybe, you knew the market well enough, you were like, this is going to happen. Even if you could see it, that doesn't mean you didn't have donative intent, right? Because you obviously could have just sold the property. That would have been a smarter move in that theory. So it's there. And they also did not agree the donors should have known it would be overstated. Now, that again is depending indirectly on the theory that, wait, you're paying this low amount, you're going to get a deduction this high amount. How in the world is that going to happen, unless they overstate the value? Because if it's known it's going to be worth that much more in a year, why in the world would anybody sell it to you at this low price? Why wouldn't they just, charge you the more reasonable price for the true value of the property? But the court didn't find that necessarily that had to be for sure known. The court gave the benefit of the doubt that there was no showing by the IRS that there was such an agreement with the appraiser, or where it was known or knowable. And the court also found that, and this is important, because the qualified appraiser rules in detail are set by the regulations, you can have substantial compliance. Now, we've talked about the fact substantial compliance doesn't work for charitable contributions in areas where you fail to provide something the code says must be provided, where the code provides specifically what that something is. And that's still the case. This case does not reverse that. This means why details matter heavily here. The regulation is written by the service, and the courts have held multiple times you can have substantial compliance with regulations because that's written at the discretion of the IRS. They have some discretion in writing it. So we can have substantial compliance there. However, when Congress says in the law that you must do A, you must have A, and defines what A is directly and unequivocally, there is no such thing as substantial compliance. If you don't comply, dot every I, cross every T, you don't get the deduction. That's why this case is not the same as a case of the gentleman years ago who got that. He made a $20-some thousand contribution to the church over the years. The church gave him a receipt for this, but it didn't say they didn't provide him with any other goods or services, even though they didn't. And they then provided that statement after he was on exam. In that case, the problem is the law said specifically that your note from the church had to say they didn't give you anything or explain what they did and the value if they did. But number two, it also said that you couldn't, you had to have it before you filed the return, neither one of which was true. And what was important, as the court noted, it's Congress that said everything I just said about that. Congress imposed that rule and very clearly imposed that rule. That's the reason why this case is different. Even though you might say, well, this is extreme, because it is. If you look at the amount with the easement, they decided, guess what? The actual transaction with Ms. Belford really establish what the value of that property at most could be. And so they went ahead and reduced easements dramatically, right? That sale from her was not a forced sale or below market sale. It was perfect, fair market value sale, buyer, seller, no compulsion to sell, no requirement to buy. It was the perfect, market sale at $4.75 million. And as you might guess, if the property as a whole is only worth $4.75 million or somewhat slightly above that, the easement's not going to be worth $32 million. And that, of course, is what the court found. It found the total gross market value of the easement at $4,718,000, way lower than what Seabrook had claimed. So not good news, right? And again, it averaged the adjusted values of the three comparable sales in the area with the from the commissioner's experts report and the price that Ms. Belford gave for her interest in Seabrook. Okay. So it said, that value that their appraiser got is ridiculous. It uses saying that was a better structure. Next up, we're going to talk about a private foundation here. This is Chief Counsel advice that discusses issues with the activities of a private foundation with regard to self-dealing, attempted correction of a self-dealing transaction, and making jeopardizing investments. Again, self-dealing, making jeopardizing investments, both are kind of bad in your private foundation. Let's say very bad. In fact, the self-dealing is a qualification issue under 501c3. And that means we may have some big problems, and this is under exam. Now, this is a Chief Counsel Advice 2025-04014, issued on January the 24th. As a Chief Counsel Advice is a memo, internal memo from an attorney in the Chief Counsel's office to the auditor who's requesting this advice about information for proceeding on the audit. As such, please keep in mind, this is the IRS's opinion on this deal, what they think is the proper treatment. This obviously could go to court. I'm sure there may be other things involved, other facts that may or may not be dwelt on heavily in the Chief Counsel advice that a court might pay attention to. But certainly the facts as transmitted in this CCA don't sound like it's going to be easy for the private foundation and the foundation manager to recover from some of the major errors that, at least taking this memo at face value, appear to have taken place. In essence, there may be some big checks being written. This memorandum discusses that examination of a tax-exempt private foundation, referred to as the foundation, and its financial dealings with business entities owned and operated by the foundation managers. Okay, actually one of them, in this case, was the big one involved. Now, the first set of transactions involves loans to this entity, which, again, a CCA, it's going to be redacted. So all we're going to know this company is Company 1, right? And we don't know amounts. That's what those dashes are if you're looking at the slides. We know the company was formed by the one foundation manager, who's going to be referred to as Foundation Manager 1. Right? Again, we're not going to use names because they redact those out of these. Now, he served basically as two positions, and those are redacted out of here because that could be identifying information. And in year 7, he owned more than 37% of the company's, voting stock, and though this interest was later decreased, right? The foundation issued multiple unsecured balloon loans to Company 1. A balloon loan is one where interest only is due on the loan, and at the end of its term, the entire balance is due in one single balloon payment. Right? Company 1 received its largest loans in years 6 and 7, and it totals amounts which are also not disclosed. Right? They're always redacted, but we can assume these are not $5 and $10 loans. I think that's a safe thing to assume. And Company 1 paid interest quarterly, and by year 15, there was an outstanding balance of what they say is H. So basically, it was balloon, and the balloon had never come due, and they had been paying interest only. Okay, so they pay interest quarterly. So that's transaction, that is basically transaction 1. Now we'll go to the second company, Company 2. Company 2 was formed by, again, Foundation Manager 1 as a State 2 limited liability company. State 2 is community property state. Now that's important because that brings into play a revenue procedure that we'll get to here shortly. Okay. He owned, basically, he owned a certain percent interest in Company 2, and Foundation Manager 2 was also active in the operations. So we have this, right? In year 13, the Foundation Managers acquired 100% of Company 2. So that's going to be the key. It received at least one loan, right, from the Foundation Manager each year between year 3 and years 12, and failed to make interest payments on some of these loans. So now, unlike Company 1 that is complying with the terms, they may be generous terms, but they're complying with the terms, Company 2 was missing interest payments, right? They were failing to live up to the terms of the note. That's somewhat important to understand. By the end of year 12, there was this nice big loan done in unpaid principal. So we have these loans to companies that the foundation managers have interest in, right? So that's where we end up going with this issue, okay? Now, the loans to both companies made up a substantial portion of the assets of the foundation. Okay, that's going to be important because what we're going to look here is a number of potential issues with that. So they were a substantial portion. As I said, these weren't $5 and $10 loans. Right? These are a substantial, big chunk of the assets of this charitable foundation. This private foundation were tied up in loans to these companies that the managers had interest in. Now, there was an attempted transfer of the Company 2 notes. In year 13, Foundation Manager 1 planned to purchase the remaining equity in Company 2, right? The tax return preparer proposed transferring the Company 2 notes to the public charities at a $0 value to remove them from the books. So, in any way, the person handling the 990s suddenly looks up and says, we got a problem here, right? Your ownership interest is going up in this thing. This is going to be now a huge problem transaction in year 13. So he said, well, why don't we just transfer it to a public charity, not a foundation, at $0 value to remove them from our books? That never sounds good, but that's okay. So not going to be on the 990 report, right? And get them off there and take care of it. The foundation and Company 2 modified the notes, extending the repayment period by a number of years to what is date 3. And again, that's a redacted number, and reducing the interest rate on the notes, right? Getting both of those together, because it looks like now, we're going to transfer it to a third party who's going to start enforcing terms. So now we're going to reduce the interest rate, extend the period before we transfer it to the other charity. Okay, that's there. Foundation Manager 1 signed the modification agreement on behalf of both Foundation and Company 2, right? And although the return preparer reported the transfers on the year 13 Form 990-PF, the notes were never actually transferred to a public charity. I don't doubt because nobody wanted them, right? Nobody wanted anywhere near this transaction. So they weren't able to do it, but apparently they reported as if it was done. Now, it doesn't say here whether, why that was done. Was that a misunderstanding where the preparer believed it had taken place? Was it an intentional move? Was he betting it was supposed to take place soon? I mean, we aren't explaining why that happened that way. But the 990-PF was frankly flat out wrong at that point. So essentially put that down there as transferred out. And apparently that was to make it appear that they had taken action and solved, and there was no problem. Okay, so let's talk about the Company 2 entity classification, right? It filed partnership returns for years 15 and 16, but did not file an 8832 to change entity classification from a discard entity to a partnership. This is now owned, and we don't really get the details in here great, but it looks like now we're looking at the husband and wife, right? They may have been the foundation managers. That's kind of what I'm beginning to say. The IRS accepted the foundation manager's treatment of Company 2 as discard entity for tax purposes, consistent with Revenue Proc 2002-69. This is where you get to the point where apparently, they're probably married. Because Rev Proc 2002-69 says if you have an LLC or similar potentially discard entity under check the box, and it's owned as community property in a community property state, then you can treat it either as a discard entity, even though it's really two owners, right? Community property means undivided interest in that is by the two people, right? Husband and wife. We can treat that either as a discard entity or we can treat it as a partnership. And 2002-69 is an interesting ruling as to what it means, and it does predate the Section 761J rules that allowed you to treat it, to treat the co-ownership, as if it was of husband and wife, as if it wasn't a partnership. That's also technically doesn't cover LLCs. It's a bit messy. This is a very specialized topic in property states, but they did that. They said disregard entity, right? However, we're going to find in this area, right, it had filed a partnership return. So they're going to say, okay, it says disregarded, but it probably doesn't matter. The foundation conceded an act of self-dealing occurred with respect to Company 2 notes in year 13 and proposed to correct this by transferring the notes to public charities. So this is on exam. Now they're saying, we're really going to do it this time. They probably would really have to do it this time. They have to find somebody to take it. And so that's also on the table before the examining agent. Does that work for that purpose? So first, they take a look at the question of, is there a self-dealing problem here, right? Well, the ruling comes down and says, look, the foundation made a substantial number of unsecured loans totaling whatever in principle to two companies that were founded, partially owned, and operated by Foundation Manager 1, right? That's, without question, is. Because he controlled the foundation's investment decisions, Manager 1 was able to direct significant amounts of capital to these two businesses in which he held significant interest, right? Company 1 received significant loans, especially in its early years, and Company 2 also received regular loans from the foundation, right? These loans constitute substantially all the foundation's assets. Yeah, major portion. I would say that's probably it, right? Became in this structure. The memorandum argues the foundation was operated by Manager 1 as an incorporated pocketbook where he transferred assets and retained control, directing them towards his private business interest. This is key. It says, look, this does not qualify for 501c3 status. This entity is not a charity. That is going to be potentially a very big problem for this entity, shall we say, in that case, because, of course, if it doesn't qualify for tax-exempt status, at least as 501c3, donations are gone, and we have a problem with taxable income from this thing, right? Company 1 and Company 2 benefited by avoiding the formalities and delays applying for commercial loans, as foundation was a ready sort of credit. We didn't have to bother with those nasty little things like the bank loan committees and all that kind of stuff. We just took money out of here because it was our nice little stash of cash, is their view. And they benefited by avoiding the formalities and delays applying for commercial loans, as the foundation was that readily source of credit, right? We talked about that issue, duplicated that a bit there on our site. The foundation continued to lend money to Company 2 despite the fact it wasn't making its payments. And that's really, so it said the motivation here was not trying to get a return from the foundation, but rather it was the company's need for funds. This is as if that sheriff in Alabama had kept sending money to the car dealership, hoping that maybe other people would invest in and be able to. No. It was governed solely by the fact that they needed the money. The sheriff in Alabama realized the problem and started enforcing things, trying to get things going and put pressure in places. What wasn't happening? Company 2 just blissfully could go on, not paying the interest, not worrying about it, and nothing was happening. They were getting more money still from the foundation. Also had control and conflicts of interest was a huge problem here. They had a two-person board fully controlled by the two managers who used the control to direct the foundation's assets to their business interest, right? It questions whether the loans were reasonable investments due to Managers 1's significant involvement in Company 1 and Company 2, right? Those just doesn't make sense, but these guys were doing it. It was huge conflict of interest for them approving these loans when they had control of those entities. That was a huge thing, right? The lack of records of any loan review by disinterested directors further undermines the ideas that these loans were in the interest of the foundation. We didn't care about the interest of the foundation. In essence, the idea being the foundation managers, because the term, basically an incorporated pocketbook suggests that they just looked at it as a nice source of funds that they could use as they wish. That is, by the way, a problem we often see when people get into certain structures where you have to pay attention to the entity's existence on its own and the entity's interests and not equate those interests with your interests, which unfortunately is what the IRS is going to accuse is happening here. Okay? the bottom line problem is the foundation served a substantial non-exempt purpose. And you cannot have a substantial non-exempt purpose and retain your exemption. That's the problem. So what's obviously being argued for here is basically its revoke exemption is what we're looking at as a very real possibility. I even say likely possibility to be proposed by the IRS in this exam. They also said it did not have any sufficient charitable activities. This gets back to why you should revoke it, right? The foundation's charitable activities are not sufficient to overcome substantial and non-exempt purpose of benefiting their owners. This was not a charity to benefit the poor and needy, in educational purposes and scientific research or anything else. It was a stash of cash to benefit the foundation's to benefit those operations is what the IRS is arguing, right? That was what it is. Even though it made, in essence, because they're saying, well, look at all these grants to charitable organizations we made. The presence of a substantial and non-exempt purpose precludes the exemption. So again, remember, virtually all of the assets of the foundation were loaned to these companies. And yes, the interest from the company loans may very well have been used to make these grants, and they might have been substantial, but it kind of tells you if they were substantial, then the loans were substantial. And you can't really bet everything on the two companies controlled, where the managers are involved. It's really tough to find that makes any sense from a fiduciary standpoint for having proper investments for the foundation to protect the charitable side of it. That's where they're going to get in the problem. They also had indirect self-dealing in cases where it wasn't direct, but there were benefits being deducted, right? It confirms that they're disqualified persons under Section 4946, okay, under those issues. Company 1 and Company 2 themselves were not initially disqualified persons. So they weren't really a bar to having transactions with as initially structured. During the year in question, Manager 1 owns less than 35% of Company 1's voting power, and Company 1 was not a disqualified person. And prior to year 13, Company 2 was also not a disqualified person because foundation manager's interest was less than 35%. Remember, that was the problem. He was going to buy the whole thing. And that's where he had the problem there in year 13 and our issues with acquiring the whole value of the company. So you couldn't say a transaction with Company 1 and Company 2 itself, just ignoring anything else, was going to be a problem with self-dealing. But we had the indirect problem here, right? Okay. Therefore, the loans do not fall under the definition of self-dealing described in Section 4941D1B. But we look at benefits now to Foundation Manager 1. The loans enabled Manager 1 to obtain financing for his two businesses he had interest in, right? The loans, therefore, constitute the use of foundation assets for the benefit of a disqualified person because Foundation Manager 1 is a disqualified person. And so even why the loan to Company 1 itself wasn't a problem, it was a problem because it benefited the foundation manager, right? It was being done for his benefit, and it was coming pretty clear. It was for his. By the way, it doesn't help you with these indirect ones when it was such a huge portion of the assets, right? Now, Treasury Reg 53.4941D-1B4 indicates transactional organizations with disqualified persons own less than 35% are not considered self-dealing solely because of the ownership interest. The memorandum does emphasize that other factors. So, they're trying to go on this reg and say, well, it's below 35%. We're fine. And they're saying that's not quite it. It's like, and we see this often when we talk about IRAs, right? And prohibited transactions. And you might say, well, it's not technically under these detailed rules that are automatic, but there is a general rule similar to this one, where if it's for the benefit of a disqualified person, and that can be very broadly interpreted, and the IRS and the courts have been, frankly, willing to broadly interpret, especially when you have facts like this, right? In this case, these factors included managers' one's control over the investment decisions, use of the control to lend a large amount of money to businesses he had founded, partially owned and operated, and the lack of any board minutes reflecting review. All that taken into account, looks like these were transactions being directed to benefit Manager 1 and Manager 1's interest. And as such, that's going to be a self-dealing transaction in the indirect sense of the self-dealing, right? So those loans were basically indirect loans of self-dealing under 4941 D1E because they represent the use of foundation assets for the benefit of a disqualified person, manager one. So there's our first problem, right? What about the correction? The foundation has conceded that in year 13, the ownership got up there. It would now be a disqualified loan, right? We had that problem. We've got the problem with this thing, right? They propose correct it by assigning and distributing the company two promissory notes to public charities, remove them from the foundation's book. So that's their proposed correction. Is that a sufficient proposed correction for this problem? My guess, Memo's going to say no. Okay, it's not sufficient. First problem is the transfer would not result in a termination of use of property by a disqualified person. The assets had come from the foundation. As use of those assets, that's the problem. It's being used by the company. The company is not having to get rid of those assets or put those assets back in the foundation. We're merely transferring the note for repayment to a public charity, right? So it still has assets. It's still benefiting from the transaction, right? Until date 3 when it's supposed to pay the whole thing back, assuming we find a charity to take this thing. And the transfer would not undo the loan transaction nor make the foundation whole, right? It's essentially going to allow company 2 to keep using the loans on a long-term basis. We're not going to make everybody whole. The idea is you've got to correct and reverse the transaction. This does not do a reversal of the transaction. Right. So at a minimum, the foundation's loans to company 2 must be repaid to correct the act of self-dealing. They're saying this is consistent with the principles found in section 4941E, E3, and Treasury Reg 534941E-1C4. Okay. How about the jeopardizing investments excise tax? There's excise tax imposed if you make jeopardizing investments, right? These Company 2 notes were considered investments of the foundation. Now, again, remember, Company 1 did comply with the terms. Company 2 did not. Okay. In year 13, they modified the loan terms, right? Change the terms of investments mean the foundation considered to have made a new investment at the time of the modification. Now, was that a jeopardizing investment? Now it's like we're going to reloan the money. That's a problem. At the time of the modification, foundation manager 1 was either in the process of acquiring, had already acquired 100% of the interest in Company 2. Manager 1 represented Company 2 and the foundation in their loan dealings, right? Creating a conflict of interest. There's no evidence of bargaining for the loan modifications, and they were made in connection with foundation manager's plan to grant the notes to public charities in order to facilitate foundation manager 1 acquiring the company, right? Acquiring that thing. Those are all problematical issues in that structure, right? How we end up doing that, okay? There was no independent review. Remember, the foundation managers were the sole managers and board members. There was no disinterested third party never looked at this and said, that's a dumb move. And I don't think any of us probably would have said, if you were asked, is it smart? Especially, you got a fiduciary liability. Is this a smart move for us to make this loan? And you're not getting any benefit from it. You're going to say, no way are you doing that while I'm sitting here. That's going to be the thought. They should have had third parties approve them rather than letting them just rubber stamp them. That suggests that, in fact, they're bad investments. If we had not made investments in companies that the managers had an interest in, then their reviewing the investments might have been sufficient. They may have the expertise to do it. But their conflicts made this very, very difficult, right? To have it go. And they failed to exercise ordinary business care and prudence, right? Manager 1 did not act prudently in agreeing to loan modifications. We had a company already not paying its loans, right? We're going to modify it to let them hold the money longer. Would a bank have really done that? It was a significant benefit to Company 2, reduced the interest rates and extended the loan terms, right? No benefit to the foundation, given a conflict of interest. Remember, the foundation had a right to be made whole on reversing this transaction, and This wasn't going to accomplish any of that, given the conflict of interest, the fact loans were a significant percentage of the foundation's assets, and the fact the modifications were made with no consideration to the foundation. Manager 1 did not exercise ordinary business care and prudence in modifying those loans. Was also a key issue. So the year 13 loan modifications fell well short of the prudent investment standard, and the jeopardizing investment tax under 4944 should apply to those. Obviously, this is basically a checklist of how to really get bad facts in a private foundation situation. I mean, I realize, clients kind of look at that private foundation structure and saying, well, I keep control. Be very careful when they say you have control, but subject to fiduciary duties and subject to these rate rules and laws and regulations. And if you think you're going to be able to use this as an incorporated pocketbook, if that's your theory, you may have trouble with the service, right? When they find out how you operate the funds, because this is an operational issue, not really a documentation issue, or how the organization's documents say it's going to be operated. This is what they actually did, was bad in that structure. Okay, let's talk about an email. Chief Counsel email 2020-504-016, issued on January 24th of 2025, where the IRS discusses the agency's lack of obligation to process amended tax returns. This was an email, so again, it's again to an attorney in the Chief Counsel's office, back to somebody else in the IRS, giving this advice. And they've been, these are emails, so they're a bit more informal, and we don't get as much, it doesn't do as deep an analysis as you would get in a full-blown Chief Counsel advice, but still does discuss the issue. And this one actually does a decent job of discussing it, right? It says in the email, there is no statutory obligation for the IRS to do anything with your claim for refund. And this is probably true. We'll have some back and forth on that, because there is a case moving through Arizona's courts involving the employer retention credit, does the IRS have an obligation to process those? And so we may see this come a little bit different, but this email comes up with citing case laws, 3 cases. The first is Goldring versus Commissioner from 1953, tax court case. The acceptance or rejection of amended return is solely at the discretion of the IRS, right? The IRS does not have to accept it. They go ahead and just file it away and never act on it, right? In the case of basically Badarko versus Commissioner, U.S. Supreme Court case 1984, the court said that these amended returns are a creature of administrative origin and grace, not a statutory requirement. So, yeah, there's nothing in the IRC that has real rules about amended returns, per se, and the IRS having to process them, right? Ramsey versus Commissioner from 2017 tax court provision also basically reiterated the same principle. They don't have to do anything with amended returns. Okay, so that said, there are administrative procedures in place the IRS has established for doing this, because they usually do process them. Remember? Internal Revenue Manuals, where you're going to find these. 3.11.6 outlines procedures for processing Form 1040X amended U.S. individual tax returns. Now remember, the IRM, consistently the courts have said, this is not binding on the IRS. This is procedural. There are some ways to yank it in, and there are some issues involved, but generally these are not considered to be binding guidance. You have to be very careful with the IRM. You use the IRM to encourage an IRS employee to follow these, because in theory they should, but it's not the same standing as if Congress had imposed a statute saying you must do X, 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 and X. Or even the IRS issue a reg saying the same thing. The IRS does, the Internal Revenue Manual does, at section 3.11.6.2, parenthesis 10, specify that employees should process amended return if it meets certain criteria. It's going to meet the following 4 items. If the routing criteria properly routed, the claim was given the proper routing into the system, if that's met. If the claim is complete, right? Everything is there with the claim to allow it to be fully processed. Right? The claim is allowable, so now they make a determination of, is it justified under the law? And is the claim processable? right? So that would be, for instance, did you send it to them within the statute of limitations time in order to make a claim with the federal government for a refund of taxes? Because, oh, by the way, you do have a legal right to make a claim. As we'll discuss, you have to make a claim. What doesn't have to happen is the IRS acting on the claim. But you do have to make a claim to get the process started if you're going to get money back from the IRS. You just may have to do extra work. Okay. It also notes that we have IRM 4.10.11.1. That guides examiners to identify the nature of amended return, determine the exam procedure should be used. It provides guidance to determine amended return is a claim for refund, a request for abatement, or audit reconsideration. Also provides guidance for examination reporting for each. So you talk down all this. Now remember, audit reconsideration, generally we're trying to reopen things that otherwise wouldn't require court done. So it's different. A claim for refund is asking for tax back. A request for abatement is requesting a penalty be abated. And so there are different ways you process each one of those. Okay. We're mainly concerned here today with a claim for refund and maybe to a certain extent a request for abatement. But, we're looking at those two. And Exhibit 4.10.11.3 provides information on taxable amended returns. They have that. Generally, the policy of the memorandum states is to process amended returns if they are valid, timely, complete, and processable. The IRS will generally process an amended return. But they're not really on the clock to do it. And as this email points out, in theory, they can just not do it at all. Okay, well, some might say, that's not good. Is the taxpayer just out of luck if you overpaid tax to the IRS? Is it just tough luck? You're depending on the good graces of the commissioner to get your refund back? No, but we'll talk about this. You do have recourse, and it's very clear what the recourse is to obtain payment of a claim. Under Section 6532 of the Code, you must take specific steps before initiating a suit against the IRS for a tax refund. You can sue the IRS for a refund. Now, remember, when you file suit, you're now in control of the thing. You've got it in front of a judge, and the IRS is going to have to follow the process from here on out. So, hint, your recourse is haul them to court. But to do that, first, you must file a claim for refund with the IRS. This is required before any legal action can be taken. Okay. Now, as I said, the IRS could sit on that claim forever. So obviously that's not the end of the process, right? You must wait at least 6 months before the date of filing the refund claim before starting a suit, unless the IRS makes a decision on a claim before that time. So basically, you file a refund claim today with the IRS. If the IRS anytime within the next 6 months says, we're denying the claim, right? They've sent the formal notice by certified mail that the claim has been denied, fully or partially, bingo, you can go to court now. And in fact, as we'll discover, a clock just started on how fast you got to get to court. If 6 months passes, the clock doesn't start, but you can go to court. So if you're tired of waiting, you just want to haul them into court, you can do that. So, and I hate to say it, that's your option if the IRS decides to just not process the claim. You would have to go to court and use a 6-month waiting period, or essentially, there's another option we've got here we'll talk about here in a second. Once the IRS disallows the claim, you receive a notice of disallowance by certified registered mail, you have to basically file your suit within 2 years of that date. That clock keeps running. As we discussed recently, doesn't matter what the service does, aside from getting a waiver of the statute, that clock's going to run at the end of 2 years. That's true even if you are before the Office of Appeals on your claim for refund, which you can take it there, but now you're the one worried about the clock instead of the IRS. So keep that in mind. Okay? Now, you can file a waiver of the requirement to receive a notice of disallowance. When you file that waiver with the IRS, right, under 6532A3, then bingo, we're done. Now, you still have to file your claim with the service because that gives them the right to pay it out. But if you're not going to wait the 6 months, you can file under 6532A3 a written notice of waiver of the requirement to receive a notice of disallowance. But once you do that, you just start a 2-year period. So what you did is you essentially provided your own disallowance. That's an option to speed it up, I guess, if you don't want to wait 6 months. Okay, that's the other issue. Any action taken by the IRS to reconsider the claim after mailing notice of disallowance, including at the Office of Appeals, does not extend the 2-year period to file suit. That's 6532A4, right? That's going to do it. It can only be extended if there's a written agreement between the IRS and the Secretary of Treasury to extend it. Now, as I said, your recourse, if they don't process amended return, it's not very good. Because going to court, meaning filing a claim for refund, a suit against the U.S. government in district court or the U.S. Federal Court of Claims, I'll get that out right. Filing in a court of claims or filing in the in the district court is not an inexpensive process. If you're talking about a claim, if you're talking about a $5,000 claim, you're going to spend way, way, way more in legal fees to get that suit filed and run to the end than you would get back with the $5,000. So that's your biggest problem with the practicality of this relief. Should that be changed? Potentially. We're talking about we talk about the Taxpayer Advocates Report. Remember, she's suggesting that the tax court should be able to handle these sorts of cases, which would make a less expensive option than having to go to U.S. District Court and have a formal suit for the refund there. But again, any change of this would take congressional action. So talk to your congressman if you want this changed. Yeah, because in fact, 6532, blocks the IRS from giving any relief unless the formal waiver is done once the 2-year period is up. They can't pay the refund, period. So, yeah, be careful there. Next up, we're going to go on to the BOI reports one more time. Now, if you just want to stop and quit listening for the day, bottom line, until we talk about the next step, whenever that happens, after the dust settled at the end of this week, you still were okay not filing the form yet and awaiting further developments, okay? But this was the case. Now, the case has changed names because we have a new administration. So while this case used to be called Texas Top Cop Shop versus Garland, or because the U.S. government was asking for the relief here of getting that injunction removed, it became Garland versus Texas Top Cop Shop. We're now substituting McHenry, who is the acting attorney general, since Merrick Garland is no longer the attorney general. So the name of the case is now McHenry versus Texas Top Cop Shop. I'm going to just call it Texas Top Cop Shop is the way we've been referring to it. I think I'll keep doing it that way. Because once we do get a new attorney general confirmed, then we're going to apparently have a name change again. So this was an application for a stay of that order that the merits panel of the Fifth Circuit had put back in place. And it was filed with the U.S. Supreme Court. The U.S. Supreme Court answered this on January 23rd. Now, they don't give much of a set of reasoning in this sort of opinion. But they did grant the government's application for a stay. So the Texas Top Cop Shop ruling, order that says you don't need to file these and they can't enforce them, that's off the books. Okay. That one, in fact, that is gone, right? So it's put on hold. It'll remain on hold while the case is being repealed in the United States Court of Appeals for the Fifth Circuit. So the Fifth Circuit can't undo this without doing its ruling. And if a writ of certiorari is sought, the stay will continue until the Supreme Court decides on the matter, right? In that case, if certiorari is denied, the stay terminates automatically. And if granted, the stay ends when the Supreme Court issues its judgment. So what this does is Texas Top Cop Shop is, for practical purposes, a dead-end case for purposes of not having to file the report, because you're only going to get to not to file the report if we get all the way to the U.S. Supreme Court with this issue. Right, so that's probably, that says that that's probably not the best place to look for eventual relief. Okay, and there is one other issue we're going to talk through in a second. Right now, because there is no requirement to file the reports, that we're going to show you why that's true. Now, I should address two other things that came in with when the Fifth Circuit when the Supreme Court issued this order. Justice Gorsuch put together a concurrence. He specifically said that the court should, he agrees that this order should be struck down, basically put on hold until everything is decided. But he specifically, and we think this means we know how he'd rule on this, he says, the court should have taken up, though, the whole concept of whether district courts can even issue orders like this that are nationwide. Now, most observers believe, based on past cases that Gorsuch has written about this, and and the mere fact he put this statement in suggests that his answer would be no, and he wants him to stop it. And I think this may be a veiled sense, because we're going to discuss one other case here, that he doesn't want 400 other U.S. District Court judges jumping in on this and issuing nationwide orders on this issue, or frankly, any other issue. He wants them to limit their orders to the plaintiffs in front of them, and he wants the court to make that statement that they don't have that level of power. But court didn't pick that up. They were invited to, but didn't. Justice Jackson had a dissent. She's not in favor of doing this. And that was probably to a few people surprising, thinking that, well, wait. She was like an appointee of Biden, and Biden was, Biden's White House was the one that was pushing, was implementing these rules eventually. And, his attorney general was the one that took this up to the Supreme Court. But her statement is one the Supreme Court would often do. And so it's surprising the court didn't pick it up and just use this as a reason to say, leave it in place. She said, she even kind of telegraphed that she probably thinks this is going to, in the end, it's constitutional. But regardless of how she feels about that, she said she didn't see the government had established why it was an emergency to have the Supreme Court step in on this at this point. She said the Fifth Circuit already granted emergency, they had expedited appeal in place. She pointed out that, in fact, the court was, the expedited appeal was in place. Everything's scheduled. It's going to go. The government had delayed implementation of this law, right? It was passed in 2021. We're here 4 years later when they decide they're finally going to turn on you got to do it. They do need to get it done by a date. I believe it was before 26. But, they waited this long. She said she doesn't see why waiting a couple more months would have made any significant difference, and why that would have made a horrible disaster occur. If we could afford not to know this stuff all the way through the first of this year, probably could afford to wait a couple of months in figuring it out. Now, as I said, that's interesting because that is an option the court could have taken. What one commentator that was interviewed in the Tax Notes Today article about this noted, and I think it's probably the case, she said, well, it becomes pretty clear that apparently the court doesn't consider having this data being delivered to the agency right now to be a compelling problem, which she says suggests that they probably see it as a valid exercise of government powers, and that these cases are unlikely, if they go to the Supreme Court, to ultimately succeed, that the law would be upheld by the court. She said, if the court doesn't think the law is valid, why in the world wouldn't they have just taken Justice Jackson's out? And simply said, nope, it's not appropriate. The government didn't show an emergency. That was an obvious out. They didn't take it, and you need to consider that. Why didn't they take it? But we have a couple other things going on. But I just said, wait, you don't need to file the reports. How could that be? How in the world could the Supreme Court be wrong about this? Well, they're not wrong. There's just another case out there. This was posted on FinCEN's website. This is a case we discussed a couple weeks ago. Remember, in early January, we discussed another case where there was a nationwide injunction issued against enforcing this rule. And that court made it pretty clear that it was because they thought this might happen. That was issued on January 7th by a different federal judge who was also from the Eastern District of Texas in the case of Smith versus Department of Treasury. That order remains in place as of today, right? That order delayed the effective date. In essence, delayed the date by which reports had to first be filed. So that delayed out the initial reports. So companies are not currently required to file beneficial ownership information with FinCEN, right? Additionally, these companies are not subject to liability if they fail to file the information. So bottom line, we don't have a problem yet. Reporting companies may still voluntarily submit beneficial ownership information reports, right? The big thing at this point, though, is this order is in place. If nothing else happens, it still keeps us from filing. The real question now, and this is a question to consider because we are getting a new attorney general. New attorney general may have different views. New administration may have different views. New treasury secretary may have different views. We're going to have to see, does the Department of Justice or Treasury decide to appeal or go back and ask the judge, at least in the Smith case, to reconsider the nationwide order? My guess is if they do that, either he sees the writing on the wall and decides to reverse it, or they immediately appeal the Fifth Circuit, who decides to reverse it. And if somehow both of those decide to dig in their heels, then the Supreme Court probably just slap it down again. I mean, it is interesting they didn't just dodge the first one. So it's an interesting concern. However, if DOJ does nothing, and if, for instance, let's say Treasury were to delay this or Congress were to repeal it, then yeah, nothing might happen, right? We could sit on this and go down this path and see what happens with regard to that. So yeah, it'll be interesting to see what goes on in this issue and whether DOJ keeps fighting the issue. Because again, they don't have to. If they give it up, then does a third party have a right to step in and do it? Then that would be like, could state governments, because they have rights to this data too, could they step in and try to force the federal government to enforce it? Keep your eyes on. More developments are likely to come. This has been the current federal tax developments for the week of January 27th, 2024. As always, current federal tax developments are brought to you by your state society of CPAs and Kaplan Financial Education. As I normally am, you can email me at edzollerscurrentfederaltaxdevelopments.com. I state that out right. We do post our updates at currentfederaltaxdevelopments.com, so you can read there about things. I am able to get more stuff together now. As I may have noted a couple of times, you may have seen on the site, I've been able to use the tool that's called Notebook LM to really, really speed up my ability to summarize things in the cases and do the background. It is a very, very useful model. Not really a large language model, it is kind of. But it is a much more restricted version and pretty easy to summarize documents. So I've been doing a bit of work, help there to get started, and then clean up what I need to and go forward. But it's very, very good, much more useful than using a large language variant, a general purpose one, because yeah, they have trouble with things like this. I'm notified, so we have done that. I will note that the mailing list kind of got broke. So if you're expecting to get updates mailed to you, you might want to go back on the website, sign up again to have the official permission, get everything together, get it done right. We're going to go down that path. So you can see there if you want it. I also do participate in certain state society connect groups. I do that for Arizona, New Jersey, Minnesota, Idaho, Illinois, and Washington. I'll take some looks in those groups from time to time. So if you have any issues or things, you can post there. And if I find it appropriate, I may respond in those areas. So we'll see you there. Otherwise, we look forward to seeing you back here in a week. We see first, does DOJ do anything in the Texas Top Cop Shop or not Texas Top Cop Shop now, but the Smith case? Where do we stand on that? What's going on there? Plus, see if we get any other developments in the coming weeks in the area of current federal tax developments.